Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's podcast episode of Legal Scrubs. Today I want to talk about uh, physician contracts, and in particular, physician contracts for new physicians going into private practice for the first time. And let's say that you are one of those physicians and you've been presented with an employment contract to review uh, with with a group practice or either a multidisciplinary group practice or maybe a single specialty group practice to go to work as an employed physician for them. And you're wondering about all the different contract provisions in your employment agreement, whether they make sense, whether they're great or they're not so good. And one of the provisions that you have in your agreement may be one that allows for the employer, your physician group, to terminate your employment agreement without cause. Now, there are essentially two types of termination clauses in contracts. One is termination for cause and termination without cause. And as you might expect, termination for cause basically provides that the employer could terminate the employment agreement if you do something wrong. And there typically would be a list of things that would give the employer the right to terminate your contract, such as being convicted of a crime or losing your medical license or things of that sort. That's not uncommon and really is to be expected. Of course, even with that type of clause, you want to make sure that the things that they have in there for that give the employer the right to terminate your agreement makes sense. But those are typically pretty straightforward and pretty easy to read through, and they're not the biggest issue for you in the sense of a termination clause. But if you have a provision in the contract that gives the employer the right to terminate the contract without cause, perhaps on 30 days notice or 90 days notice or even longer, 180 days notice, it essentially gives the employer the right to end your employment relationship with them for any reason or for no reason. And these are not that uncommon either. The problem you might have with a termination without cause provision, well, there are a number of problems. I'm going to point out two today. One would be if you go to work, let's say that you go to work for a group, either a single specialty or a multi-specialty small group practice, and let's say that you travel and move all the way across the country to join this practice. Maybe you're married, maybe you're not married, but let's say that you have a young family and you travel across the country to join this practice. And let's say you get settled into your new community and you buy a house and you get settled and you become part of that community. And then let's say you have a 3-year contract with this group, and let's say you're doing great and you're getting involved in the community, you're making friends, you're doing great work in the practice, you're getting patients, your patients really like you, and you're enjoying your practice. But let's say that 2 years in, for no reason at all, the group decides they want to terminate your practice. Maybe it could be, like I said, it could be for any reason or for no reason. Maybe the practice just is not as busy as it thought it would be and decides to just cut back on the number of employees, and it just one day comes to you and says, we're going to have to terminate your contract. We're giving you whatever the required notice is, and that's it. Your employment's going to be terminated. If you have a provision in your contract that says that the employer can just terminate your contract without cause, in that event, two things I'm going to talk about today. One is, what do you do about malpractice coverage going forward? Because if your employer has been providing you with malpractice insurance, it's most likely that the type of insurance they're providing you is claims made insurance. There are essentially two types of malpractice insurance: claims made and occurrence insurance. Now, claims made means that as long that if a claim is made against the insurance, if someone brings a malpractice case, brings a claim under that insurance policy, as long as that policy is in effect when the claim is made, then you're covered. Occurrence type policy provides that if a policy is in effect and the occurrence that gives rise to the claim occurs during the time that the policy is in effect, then you're covered. Now, with a claims made policy, which is the most common type of malpractice policy, is in place with your employer, and you were to leave the employment of that employer, if that policy terminates with respect to you, you're no longer covered when you leave the group, and a claim was made a month after you leave the group. That means the claim would have been made during a time when when the policy is not in effect with respect to you, which means you would not be covered under that policy. Now, if an occurrence type policy was in effect with the employer, you would be covered, because if the policy was in effect during the time you were working there, the event that gave rise to the claim, the occurrence of that event that gave rise to the claim would have been in effect while you were covered by the policy. So it wouldn't matter that the claim was made after you left, it would still be covered. But in most instances, malpractice insurance is going to be claims made coverage most of the time, because claims made insurance is cheaper than occurrence insurance. So one thing you need to do when you go to work for a practice is to determine up front what type of malpractice insurance the group is going to provide for you. Is it going to be claims made, or is it going to be occurrence insurance? And if it is claims made, which most likely it will be, will the practice provide you with tail insurance? In other words, extended coverage if you leave the practice because they have essentially asked you to leave under a termination without cause provision. So, in other words, if you're 2 years into a 3-year contract and the group says, we'd like for you to leave, you've done a great job, but we, for whatever reason or for no reason, we don't want you to remain here, and they have been providing you with claims-made insurance coverage, you should want them to provide you with coverage after you leave, since they asked you to leave under a without cause termination provision. So on the front end, when you're negotiating your contract, you should look at first making sure you know what type of insurance is being provided to you, and second, if it is claims-made insurance, negotiate if you can to have the group provide you with tail insurance in the event the group terminates your employment agreement without cause. That's the first thing. The second thing that I'd like to point out with respect to a termination without cause provision is it's not uncommon, in fact it's usual, for an employment agreement to provide that you are going to be subject to a covenant not to compete if you leave the practice. In other words, it may say something along the lines of, you won't practice within 10 miles of the practice site or within the county in which the practice site is located for a period of 2 years after you leave the practice. Now, going back to my example at the beginning, if you have moved across the country with your family, you've gotten integrated into the community, bought a house, joined clubs, made friends, and more importantly in this context, made patient relationships with your patients, gotten involved as a physician in the community and have patients that you would like to continue to provide services to. If you have a covenant not to compete and you're asked to leave under a termination without cause provision, then you're kind of in a difficult situation, because if you have a covenant not to compete, even if there's a termination without cause, you're going to be unable or restricted from practicing medicine within a certain geographic area for a particular period of time as set forth in the contract. It may be that you can't work in that county anymore. It may be that you can't work within so many miles of the practice site anymore for a period of up to 2 years. Now, it could also be that the covenant not to compete simply says that you can't provide services at any healthcare facility at which the practice provides services for a period of 2 years. And so if you're a hospital-based physician and there's one hospital or two hospitals in an area where you've been practicing, and your group provides services at both of these hospitals, and that's where all your patients are going to be, and you're prohibited from or restricted from working at those hospitals for a period of 2 years, what are you going to do? You may not have privileges at any other hospital, and it may be that the closest next hospital is many miles away, and it's not where your patients are. And there you are, you might be forced to start over with your practice. So on the front end, you might want to try to negotiate with your group that if your contract is terminated without cause, that the covenant not to compete is simply not there, goes away. Another option is to, if you have say a 3-year contract, say that the covenant not to compete goes away after 1 year or 2 years or something like that. You need to do something to protect yourself as best you can with respect to the imposition of a covenant not to compete, particularly in the case where your contract could be terminated without cause by your employer. So those are just a couple of provisions or a couple of impacts that you could have from a provision in your contract that gives the employer the right to terminate your contract without cause. The tail insurance coverage issue with respect to malpractice insurance, and the covenant not to compete issue with respect to a termination without cause provision. There are a lot of other provisions in an employment contract that are important to a physician, including what are the on-call coverage requirements, things of that sort. So it's very, very important when you're entering into maybe your first contract as a physician to look at your contract very, very carefully. Don't just sign it without reading it and understanding it completely. And it does often make sense to have an attorney who is familiar with employment contracts, and particularly with physician employment contracts, to take a look at your contract and advise you on some things that you may wish to try to negotiate with your new employer. Okay, I hope that helps for today's episode of Legal Scrubs, and we'll see you next time.